Lynn Kenyon, Everything Montana Real Estate, in conjunction with Live in Montana Real Estate. This is our whole series on every aspect of real estate that we can think of that we hit. We're going to have a whole plethora of things and videos and podcasts. And today we are talking Brian Lee, who's an attorney in Shelby, does a lot of real estate law. And we're going to have 3 separate videos on his, but the one we're going to work with right now is probate and estates. Those are big. When I'm dealing with an attorney in real estate, I see a lot of probate. A lot of somebody inherits a piece of property, they want to sell it, and then divorce, sadly. Joint tenancy, who owns it, what happens in a divorce. So probate, can you walk our viewers through what your people are coming to you, somebody dies, what do they need from you?
So probate's the process by which a personal representative is appointed by a court. It's usually in the county in which the decedent, the person who died, resided. And it's the process of having the court appoint that personal representative who then has the legal authority to administer the estate. And that includes identifying all the assets the decedent owned, identifying any creditors that the decedent might have owed money to, and preparing an inventory of all the property that the decedent owned. And once everything that's required during the probate process has been completed, then eventually the property that's owned by the decedent would be distributed out of the estate pursuant to the will if the decedent died with a will, or pursuant to Montana's intestacy laws if they didn't have a will.
Intestate, yeah. Okay, so recently, for whatever reason, I've just had a lot of probate scenarios. People inherit, someone in their family dies, they inherit. They have to sell quickly because you inherit the property. Somebody's got to still be paying the utilities and the property taxes and all the maintenance on a property. They're like, oh, we've got to wait until probate's settled. That's not true, is it?
No.
How does that work?
So what typically happens in scenarios where somebody's died, the family, whoever's responsible, like I mentioned earlier, usually people have a will and it designates someone to serve as a personal representative. That would be the person that should step forward and then hire an attorney to petition the court to be appointed as personal representative. Once they've been appointed in that capacity, they have the legal authority to sell the property. Title companies always get a little bit jumpy about sale of properties within the creditor claims period, which is a time period that creditors of the decedent have to present their final claims against the estate. So the way we typically address that is if you're able to get a buyer and a signed buy-sell and you're able to proceed towards closing before that creditor's claims period has expired, the proceeds from the sale just need to be segregated into an estate account until after the creditor's claims period has expired. So if claims do arise, the funds will be there to deal with it. And that seems to satisfy the title companies. But there's no reason why you can't complete a sale of real property after decedents died and before the probate's settled.
Okay, so somebody dies, a PR, personal representative, gets appointed, they sell the property, you can't touch that money is what Brian's saying. So it's going to get put aside, and just in case somebody comes along and says, hey, he never paid me for painting the house, and if everybody spent the money, that person is out that money for painting the house, and the title company's in the middle of it. So that's their conservative approach to we don't want you to sell, but you can legally.
You absolutely can.
Okay, so it's a PR. What if they die intestate? They die without a will. How does that work?
So Montana has adopted the Uniform Probate Code, which has a statutory scheme or what they call a statutory will that provides what happens to your property when you die without a will. Under most circumstances, if you're married and you have no children from a prior relationship, everything goes to your surviving spouse. If you're not married, everything goes to your children. If you're married and you have children from a previous relationship, then it depends on the total value of your estate, because there's provisions made for the surviving spouse to receive a large sum of the estate initially, and then anything in excess of a certain amount would be split between the surviving spouse and the prior children.
Okay, but if you have a will, then it's different. Then you go by the will.
It's the same process. You're still going through probate, but determining how the property gets distributed out of the estate is determined by the will or by the Uniform Probate Code provisions that are applicable to the specific circumstances.
Okay. Do you see fighting between siblings and that sort of thing often when you get these, when somebody passes?
Lots of fighting among siblings, but it's usually because of something that existed prior to the probate starting. It's just this is an opportunity for them to re-engage with each other. But I mean, the reality is the will or if it's under intestacy, it's fairly straightforward. The fights usually develop over things like division of the tangible personal property. So mom's jewelry or vehicles or guns and things of that nature. That's typically where the disagreements arise.
I just had one where the POA, so I had a listing, the POA had me list a property. Then they died, and then the PR took over, and they took precedence. So the POA, when Dad was alive, allowed her to do things, and then he died, and then the PR was in charge at that point. So the POA, which is a power of attorney, is different than a PR, I guess is my point.
Correct. The power of attorney is only valid while the person granting that power of attorney is alive. Once they die, the power of attorney terminates, and that's what then somebody, whoever's designated in the will or whoever has priority of appointment under the statute, if there is no will, has to petition the court to be appointed as personal representative. And then they just basically step into the shoes of the decedent and then can manage the estate accordingly.
I think that's an interesting one, that POA, because everybody thinks, oh, in the POA he died, and then I can still continue to do things. So that expires when he expires.
Correct.
And then you start over.
You basically are left now with having to deal with the probate process, unless other arrangements have been made to provide for the transfer of the property via transfer on death deed or something similar like joint tenancy.
Okay. Let's move into divorce. Okay, so you divorce. Typically, when you buy something, joint tenancy, can you explain what so you buy a property, if you're married, typically, or your mom and dad, however you do it, joint tenancy is a lot of times how these deeds are held. Explain what that is and how that works in a divorce.
So there's two types of tenancy in Montana, and tenancy is just a form of ownership. Joint tenancy is a form of ownership that provides that if you and I buy a piece of property together and I die, the joint tenancy terminates on my death and you become the sole owner of the property. Tenants in common is the other form of ownership, and that's basically if you and I buy a piece of property and I die, whatever my will says, or if I don't have a will, whatever the laws of intestacy provide, my property will pass in accordance with that. And you keep your interest in the property, and my interest passes to my heirs.
So you own 50%, I own 50%.
If that's how it's set up.
In tenants in common.
Correct.
Or if there's 4 people, each one has a quarter. So yeah, tenants in common is a little different. But typically in a marriage sort of situation, it's joint tenants where I die, you get it, you die, I get it. And I see that sometimes with parents and kids and that sort of thing. They'll do a joint tenancy if there's not another spouse. So what do you see in divorce in real estate other than just joint tenancy? What happens? I mean, if in a dispute, how does that work? What are we seeing most often?
So in a divorce, one of the early orders that the court will issue is a restraining order preventing either the husband or the wife from disposing of any assets without court approval. And that's to prevent and protect the marital estate during the dissolution process. Doesn't mean that assets can't be sold, but it typically would require the consent of both spouses to do it or court approval to proceed with doing it. But
so don't get a divorce and say, oh, I'm going to hurry and sell this before she gets her hands on it because she's cheating fool and I'm going to sell it and show her off. It ain't going to work like that.
The economic restraining order prevents you from doing that, and there can be serious consequences, including criminal contempt, if you violate that order.
Whew, did you hear that? Don't do it. That's big.
At some point, there should be either the court will decide how the property that's owned by the couple will be divided up between them, or they reach a settlement agreement without the need for the court to be involved. Under either scenario, there'll be some provision for what will happen with the house. Usually, most circumstances, one of the spouse ends up with the house. And in that case, the party that's not keeping the house will sign a deed conveying their interest in the property back to the other spouse. The one thing that people need to be
quitclaim deed.
A quitclaim deed, a grant deed, it doesn't matter. Just something that is essentially transferring the spouse who's relinquishing their interest in the property back to the other spouse that's going to keep it. That needs to be recorded to remove the spouse's name off the title, leaving the one spouse vested with exclusive ownership.
What if there's a mortgage?
That's the thing I was just going to mention. That's complicated because most times when the husband and wife sign those loan documents, they're signing jointly and severally, which means they're both on the hook for that debt. And the banks are generally loath to release one of the spouses from that liability. I'm not. You have to ask each specific lender what their protocol is. Some of them make it very simple. Others require that the property be completely refinanced, going through the entire loan process, paying all the lender-related expenses, title cost, all of those things, and basically completing that process to get the other spouse's name off, and then have them be released and free and clear of the debt with the bank.
And sometimes they're not going to qualify.
Sometimes they may not qualify.
As themselves, yeah, without the other party.
And I've seen scenarios where the parties have completed their dissolution of their marriage and they divided up all the property, and one spouse keeps the house, the other one leaves and moves out of state or whatever. And maybe they conveyed their interest in the property to the spouse that kept the house, but they're still on the hook for the loan with the bank.
Interesting, because they won't release it.
And then the spouse that keeps the house defaults on paying the mortgage for whatever reason, and now that's affecting the other spouse's credit and impacting them in other ways as well.
Wow, so another good reason to come talk to an attorney. Well, when the divorce you do anyway. So yeah, you do those do-it-yourself home kits on getting a divorce. You may want to consider that there's more involved than just saying, okay, we'll do this and that. There's a lot involved, so definitely talk to somebody about that.
I think your advice to seek legal counsel on these matters is important, making sure that you get somebody that's competent in the family law area. Lots of attorneys in Montana, but family law is a very specific area of the law that there's a lot of intricacy, and it's important that you get good advice from somebody that's practiced in that area of law for a good period of time.
So those family law attorneys also deal with real estate just because of the nature, because it's always involved.
Correct.
Interesting. All right. Well, thank you for joining us. Lynn Kenyon, Everything Montana Real Estate, in conjunction with Live in Montana Real Estate. Brian Lee, just so much information, and why you should talk to an attorney when you get in these really complicated scenarios in real estate. Thank you for joining us.